Hello students, in this video we will discuss regarding an important topic of Disputes Act, that is modes of settlement of the dispute. If dispute is not there, it is quite a good position. If dispute is there, what are the modes to settle these disputes? So we will be discussing various authorities who will be investigating regarding these disputes. You have to learn this diagram very thoroughly. What are the authorities under the act which will help in the settlement of dispute? First is you have to prevent the dispute, and the dispute prevention is the responsibility of work committee under section 3 of the act. Second is, if still the dispute arises, it has to be done by the conciliation, and it will be the task of two people: conciliation officer under section 4 and conciliation board under section 5. So these two people will be having the responsibility of conciliation of the dispute. Third is this, the investigation of dispute is very important if it is there, and that will be done through the court of inquiry, which is known as COI. Fourth is adjudication of the dispute. If dispute is not settled by these three methods, then the dispute is referred to the courts. And the first one is labor court, second is industrial tribunal, and third one is national tribunal under section 7. And finally, the dispute can be settled by an arbitrator as well, and a voluntary arbitrator can be appointed under section 10 subsection A. So these are the 5 authorities under this act. You have to remember there are 5 authorities under the act that will be dealing with the disputes if it is there in the industry. First, you have to prevent the disease by the work committee, and if still the dispute is there, we have to go for the conciliation by the conciliation officer and the conciliation board. There will be investigation of the dispute by court of inquiry. Otherwise, the dispute will be referred for adjudication in the labor court, industrial tribunal, or national tribunal. And finally, the dispute can be referred to the arbitrator also under section 10 subsection A. So these 5 authorities, keep these in mind. So we are going to start these 5 authorities one by one. First is prevention of the dispute, that I just told you. Prevention is the responsibility of work committee under section 3. So you have to remember, section 2 was dealing with the definitions that we have done in the previous video, and section 3 is the section of work committee. Now, why the work committee? Work committee has been designed with the idea that there should be joint consultation between the worker and the employer. That is why the work committees are created under section 3 subsection 1 of the act. Now, what will be the constitution of the work committee? Who will be the people in the work committee? There will be representative from both the parties. Both the parties means employer and employee. And work committee has to be made in the organizations in the industry where 100 or more workers are employed. It means the dispute is not there. We are trying to prevent it so that there is no dispute in the future. So whenever 100 or more people are there, design a work committee in the industry. And if 100 workers were employed in the preceding 12 months, it is a precondition that you will have to appoint a work committee over there. Now, the next is who is going to establish this work committee. This will be the responsibility of the appropriate government to have the work committee. So, appropriate government will be looking that if there are 100 or more workers, you have to make a work committee. Now, who will be there in the work committee? Both the parties will have equal representatives. If 2 are from the workers, 2 will be from the employers. But there is a point that the worker representative should not be less. If employer is 1, the worker representative can be 2 also, but it can never be less than the employer representative. And the representative will be chosen in consultation with the trade union. It will be the trade unions who will be referring the people for the work committee. So this was about the constitution of the work committee under section 3. Now next comes, what are the duties of the work committee under section 3 subsection 2? What will be the work of work committee? First is joint consultation to be given by the workers and the employers. They will be jointly sitting and consulting the matters. They will try to promote the measures for ensuring good relations between the employer and employees, because we have told still there is no dispute, but dispute should not be there also. So they will try that measures should be taken that good relations sustain. They will always discuss the matter of common interest and concern. They will settle if there is any difference between the workers and employers, and such matters should not crop up in serious dispute. So they will try to reduce them. And they will give a free hand to the parties to discuss, argue, agree, rebut, and ultimately come to a common conclusion. So there will be joint consultation in the work committee. So this was about the work committee. This was about the first part of the dispute settlement redressal machinery. We have discussed the work committee. Second is, first part was prevention. Now second is conciliation of the dispute. B part of that diagram that we have done. So conciliation, in conciliation there will be two important parties. First will be conciliation officer and second will be conciliation board. If conciliation officer can handle the dispute, well and good. If not, then we will be going towards the conciliation board as well. Now, first of all, just one important thing is there, that the dispute, before the dispute is referred to any court or tribunal, it comes for conciliation. Now, conciliation officers have some duties which have been given under section 4 of the Act. Now, what are these duties? Now, the conciliation officer can hold any conciliation proceedings whenever they require conciliation proceeding to call the people under section 12 subsection 1. Conciliation officer can do it. He can investigate about the dispute and he can promote the amicable settlement. So whenever he feels that there is a dispute, he can call the people and he can focus on the amicable settlement of the dispute. Third one is, then he will have to prepare a report that whether the party agreed or not. If the parties agree, he will be preparing a report and both the parties will be signing a memorandum of settlement under section 12 subsection 3. So this is the task of conciliation officer. Fourth is, even if no settlement has been arrived by the parties, still he will be making a report under section 12 subsection 4. Then is under section 12 subsection 5, he will be referring it to the appropriate government. Now report which is being prepared, it will be given to the appropriate government and appropriate government will further proceed. If the parties are not satisfied by the conciliation officer, it will be further referred to the labor court, tribunals, national tribunal. Who will refer it? It will be the appropriate government. If the parties have not reached any settlement, appropriate government can make it further proceed. Now there is a time limit for submitting this report. When the conciliation will submit the report, time limit is 14 days. Remember this point, time limit is 14 days for the conciliation officer to submit his report to the appropriate government. Next is conciliation by board of conciliation. Now earlier we have done conciliation officer, now comes the board of conciliation. Now of course board will be a collection of people. The earlier we have done, it was officer. Officer means one or more, but board means it will be a collection of people. Now what will the board do? Same tasks that the conciliation officer has done, that will also be done by board under section 5. They will investigate the dispute and will try to reach at amicable settlement under section 13 subsection 1. Same, they will be preparing a report and there will be memorandum of settlement. If the parties agree upon the settlement which is done by the board of conciliation, they will be preparing a report. Even if no settlement has been done, they will be preparing a report under section 13 subsection 3. And that report will be sent to the appropriate government that no settlement has been arrived. What the appropriate government will do, it will refer the dispute to either labor court or industrial tribunal or any other national tribunal. And finally, the time limit for submitting the report. As we have done that, the report of the conciliation officer was to be sent within 14 days. Now here in this case, the report in the same manner it will be prepared, and for sending the report the time period is 2 months. That is the main difference between the conciliation board and the conciliation officer. For conciliation officer, time period was 14 days. Now for board of conciliation, a detailed inquiry will be done, so they have been given extra time, that is 2 months. Now we have discussed that there is a difference between conciliation officer and conciliation board. So I told you that board will be a collection of some members. So who will be these members? First of all, there will be a chairman who will be appointed by the appropriate government. Besides the chairman, there will be 2 or 4 members. 2 means one from the workman, one from the employer. If 4, then 2 each. So there has to be equal number of members from both the parties. Now, what they will do is, then they will send the report with the memorandum. And these parties are like, what they are going to do, the chairman and 2 and 4 members, they will, if the parties have settled the dispute, they will send a report. If the parties have not settled a dispute, they will tell the appropriate government that the settlement could not be done. Another important point is quorum. Quorum for the meeting. Whenever meeting is done, if total number of members are 3, the quorum for the meeting is 2. If total number of members are 5, then quorum of the meeting will be 3. Now, how 3? We have told that there should be equal number of members. It means if one is from workman, one is from the employer. So 2 people and plus 1 is the chairman. So total 3 members. If 3 members are there to conduct a meeting, 2 must be present. If you have to do any voting or something, 2 should be there. And if from both the parties 2 plus 2, 2 are employed people, 2 are employee people, total 4 people plus 1 chairman, total 5 people are there. And if 5 people are there, then the quorum for the meetings is 3. So these things you have to remember. So here we end up with the second part of the redressal machinery. Coming to the third part. Now if the dispute could not be settled with the help of conciliation, now what will we do is, the third method is investigation of the dispute, and this investigation is done by the court of inquiry. Now, as the name suggests, investigation. Now you have to investigate the dispute. Now, like Board of Conciliation, Court of Inquiry is not a permanent body. Whenever a dispute is there, appropriate government creates a Court of Inquiry. Now, who will be the members for the Court of Inquiry? There can be one or there can be more independent persons as the appropriate government thinks fit. In case the Court of Inquiry consists of 2 or more members, one should be appointed by the chairman. One person will be appointed by the chairman itself. Now, Court of Inquiry, for conducting the Court of Inquiry, some provisions are there which are quite important under section 6. First is, they have the powers which are not fixed, that they can follow any procedure to conduct the inquiry. Why the dispute has arisen, who was the person responsible. So there is no fixed procedure. They can go with the flexible procedures, and this power is given under section 11 subsection 1. Second is, they can enter into any premises of the industry for the purpose of inquiry under section 11 subsection 2. They will be enjoying, the members of Court of Inquiry will be enjoying the powers of a civil court. The powers which have been given to a civil court, same powers they will enjoy under section 11 subsection 3. They can appoint the assessors also if they require. Independent persons are required, specialized people are required. For example, medical opinion is required. So they can appoint such persons under section 11 subsection 5. The members of Court of Inquiry are considered to be public servant. They will be the government employees, public servants under section 11 subsection 6. And here we end up with the third part of the redressal machinery. Coming up to the fourth part, if the Court of Inquiry or investigation also could not do anything, now the dispute will be adjudicated to the courts now. Now the entry of courts will be there. So 3 type of courts, 3-tier system is there involved. First one is labor courts, second is industrial tribunals, and third one is national tribunals. So just let us see them briefly. First of all, what is a labor court? Now, appropriate government has been given the power that they can, by notification in the official gazette, 1 or more labor courts for adjudication of the disputes. And which matters will be considered here, that have been given under the second schedule of this act. So you have to just go through the second schedule, the matters which have been specified in the second schedule of the act. For those matters, you can go to the labor court. So who will be there in the labor court? Under section 7 subsection 2, labor court shall consist of one person which will be appointed by the appropriate government only. And under section 7 subsection 3, the qualification of that person who will be working as a presiding officer are being given. Who can become a presiding officer? He should be or has been a judge of high court. He has been a period or not less than 3 years a district judge, or he can be an additional district judge. He has held any judicial office in India for not less than 7 years, and he has been the presiding officer of labor court constituted under the Provincial Act or State Act for not less than 5 years. So these are the 4 criterias. If these are fulfilled, the person can become a presidential officer, presiding officer of the labor court. Now next thing is, what is the scope of adjudication? As I told you, only the matters which have been given under the second schedule of the act, they only for those matters you can go to the labor court. So which are these matters? First is propriety or legality of any order which is passed by the employer. Any standing order has been given and worker is not satisfied with that. Application and interpretation of any standing order. The standing order has been interpreted in some other manner. Any worker has been discharged or dismissed, including the reinstatement or grant of relief and wrongful dismissal. Withdrawal of any customary concession. Any customary concession or any privilege was given which has been withdrawn, you can go to a labor court. Illegality or otherwise of any strike or lockout. You feel that any strike or lockout is illegal, you can go to the labor court. And any other matter except the matters which have been given in the third schedule, any other matter, for that you can go to the labor court. Now after the labor court, in the 3-tier judicial machinery, the second is industrial tribunal, and the section is section 7 subsection A. The major points are going to be the same that we have discussed in the labor court. Section 7 subsection A states that appropriate government can make one or more industrial tribunals for adjudication of the dispute. And for which matters? For the matters of second schedule and the matters of third schedule. For them you can go to an industrial tribunal. Who will be the person over here? Only one person, which will be appointed by the appropriate government. Same point. Section 7A3, what will be the qualification? More or less are same only. Here also we are going to appoint a presiding officer of the dispute for the tribunal. He is or has been the judge of high court, or he can be a district judge or additional district judge for not less than a period of 3 years. However, appropriate government, if it thinks fit, he can appoint 2 persons. 2 persons can be appointed who are going to advise this presiding officer. So he can appoint 2 more persons for that. Now, when to go for the industrial tribunals? Of course, for the matter relating to second schedule and third schedule. Second schedule we have already discussed. In the third schedule, these matters have been discussed. So if you want to go to the industrial tribunal, these are the matters. The matter related to wages, time period, mode of payment, compensatory and other allowances, how many hours you are working, you are not getting the rest hours, the leave with wages you are not getting, holidays you are not getting, bonus, profit sharing, provident fund, gratuity, shift working, otherwise then in accordance with the standing orders, classification by grades, discipline rules, rationalization, retrenchment of worker, retrenchment and closure of the establishment, or any other matter that may be prescribed. If the government is prescribing any other matter, for that also you can go to the tribunals. Now after this, the third tier in that system is National Tribunal, which is being covered under section 7 subsection B. The National Tribunal is always constituted by the central government. As in earlier cases we have discussed about appropriate government, but National Tribunal will be always designed by the central government. So central government can constitute one or more National Tribunal for the adjudication of industrial dispute, and these will be the only dispute where the question of national importance arises. So whenever the dispute is going to affect one or more states, and that can be a dispute of the nation, for those disputes, National Tribunal will be designed. So which matters can be discussed here? Both second schedule or third schedule can be discussed here. Now who will be the people in this tribunal? Section 7B subsection 2 states that only one person who will be appointed by the central government only. Section 7b subsection 3 states regarding the qualification of that person who is going to be the presiding officer of the National Tribunal. He is or has been the judge of High Court, can be appointed as a presiding officer. Now, another important point is there under section 7b subsection 4, if the central government thinks fit, he can appoint two another persons to help the presiding officer. Two people who are known as the assessors. They will be advising the National Tribunal how to go about with the proceedings. The next is, what is the scope of the National Tribunal? What type of topics can be discussed in the National Tribunals? First is, if any problem that is of national importance, you can refer that dispute to the National Tribunal. If there is any dispute which can affect the establishment in one or more states, it means now it is a matter of one or more state, you can refer it to the National Tribunal. And third is, the dispute may relate to second schedule or third schedule. Any of the schedule hardly matters. Now this was the fourth part of the redressal machinery. Now we will move on to the fifth part. After adjudication, the final stage is arbitration. Now in arbitration, the authority for arbitration has been given to the arbitrators. So it is a voluntary arbitration under section 10 subsection A. Now what does arbitration means? Arbitration means the parties are being given the opportunity that they can get their disputes settled by a mutually agreed third person who will be naming as an arbitrator. So therefore it is laid down that where industrial dispute is existing or apprehended, employer and workmen combinedly they will sit and they will decide about a third person and they will refer their dispute to that person, and whenever they are doing this they have to sign a written agreement that mutually we are deciding about a third person for the arbitration. They have to sign a written agreement for that. But they can refer the dispute to arbitration at any time before the appropriate government exercises his power and refers the dispute to the courts. This step is very important. It should be done before the dispute has reached to the National Court, Labor Court, Tribunal. Before that, you can go to the arbitrator. Further, in agreement to refer the dispute to arbitration shall be made to such person or persons as the case may be agreed upon by the parties, including the presiding officer of the Labor Court, National Tribunal or Industrial Tribunal. So an agreement has to be signed before the problem has gone to the courts, and that agreement must be signed by both the parties. Now there is a procedure to go to the voluntary arbitration. You cannot go it like that. There is a process for that also. The first step is you have to sign one agreement for this arbitration agreement. Both the parties, worker as well as the employer, that they will be signing an agreement that we are willingly going for arbitration. Second is award by the umpire. Umpire will be an independent person. When will this umpire come? When there is a one or two arbitrators and they are equally divided in their opinion. One is saying one thing, other is saying other thing. So it is impossible to arrive at a conclusion. So umpire will be intervening. He will be an independent arbitrator and his decision, his award will be the final award. Then is copy of arbitration agreement, that agreement done in the first step. It will be sent to the government. Now this agreement will be sent to the government also and to the conciliation officer also. And appropriate government will be publishing this within 1 month in the official gazette, that these two parties have decided to take the dispute to an arbitrator. Then the arbitrator will be investigating about the dispute, and then he will be submitting the final award which he will be signing also. So these are the 4 important steps how the arbitration will be moving ahead. Now once you go through all these 5 stages, the redressal machinery of the Industrial Dispute Act is complete. So 5 stages are very important. You have to keep that diagram in mind, that what 5 things we have done. So first of all, we have tried that the dispute should be prevented. Instead of just moving ahead with the dispute, we have to prevent it as early as possible with the help of work committee. Then we have moved to the conciliation with the help of conciliation officer, conciliation board. Then we have moved on to investigation through the help of court of inquiry. Then we have gone to adjudication with the help of labor court, industrial tribunal, national tribunal, and finally we have gone to the arbitration with the help of voluntary arbitrator. So this is all about the redressal machinery given under Industrial Disputes Act. Thanks a lot.